Happy Father's Day. If you're watching live, you're watching on Father's Day. Big day today. Glad we got some people out there. And I'm sure we'll get a few more, as we always do. YouTube Live number 16 out of 20 daily, unique, different YouTube Live presentations, all related to estate planning. Like to give you just the practical knowledge that you can take and use in your own personal circumstances. So got a lot to jump in. So I do want to talk just for a minute about Father's Day. If you've watched any of my other videos, you probably know I don't talk too much about my personal life. And the reason I don't is, quite frankly, because I don't like, when I watch other videos to learn, I don't like those other people who are making videos, spend, go on and on about their personal life when I went there to learn. But so I'm going to make a slight exception just because it's Father's Day. My father passed away about 4 years ago. He was an engineer, worked for a company called Dow Chemical, and just was very honest, righteous. Never heard him raise his voice ever in his lifetime. Never heard him say a curse word ever in his lifetime. Just a very, 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 very great man. So he was the best man in my wedding. And then my wife, Amy, and I was one of five. My wife, Amy, and I have 5 children. 4 boys. Our daughter is the youngest, and we couldn't be prouder. So my oldest son is a lawyer, does mergers and acquisitions. My second son is a lawyer, works in-house counsel for a big firm. Third son is at Tulane Law School and is working virtually this summer for a Houston law firm. He has 1 more year of law school left. And then my 4th son is preparing to take the law school admissions test. None of this was at my persuasion at all. I want them to go find their passion. My youngest daughter, she'll start her 2nd year of college next year. She plans to go to law school, is what she tells us. So very proud. They've all been really, really good students and really, really good children. And so I'm very honored on today, Father's Day. I'll probably get a couple of calls because I know at least one of my sons has been trying to call me. We've missed each other. So so as appropriate, I give the Father's Day little dad joke there. Felt like it was relevant. Appreciate the additional joke, one-liner, whatever you call it, from Ron. Ron and I, if y'all want to, contribute, feel free. But Ron and I are stepping our games up by providing some humor every day. But we're not going to quit our day jobs. Okay, big topic here. It's a topic that everybody seems to want to know about. Everybody seems to want to address it. The old Paul. How do I make sure my bank accounts don't get frozen when I die? Or usually it's asked in another way. Paul, if I go add my son to my bank account, then the array of questions comes. Can they get it when I die? If they get sued, will I lose my money? Is it their money when I die? Do they have to share it with my other children, my other heirs? Will it get frozen when I die? So there's all those questions. I wish I had a nickel every time I was asked a question related to the freezing or access to a bank account, either during somebody's lifetime or when they die. So that's what we're going to get to the bottom of. I'm going to give you maybe 5 different ways to structure it. You'll figure out perhaps which way is the best for you. But most people would prefer that at least one or more of their survivors, heirs, children, most people would prefer that someone have access to their bank accounts and those bank accounts not be frozen upon the death of the account owner. And I think most people want that because happy Father's Day to you as well, Slim Dog. Appreciate the courtesy. Most people know that there's going to be expenses that will need to be incurred when they pass away, whether those are expenses related to funeral expenses or service expenses or legal expenses. And most people who are kind of preparing to make it easy for their survivors, they don't want those survivors to have to dip into their own pockets to pay for those expenses that are, related to their mother, father, aunt, uncle, grandparent passing away. So it's an issue that just about everybody has. And I just want to make it clear what we're talking about on this video. One is we're talking about really bank accounts. Really what we're talking about is bank accounts and credit union accounts. I'm going to refer to them collectively as bank accounts because they pretty much have the same rules. What we're not referring to is brokerage accounts. Completely different set of rules on your brokerage accounts that you may have at Charles Schwab or Vanguard or Fidelity Investments or Merrill Lynch or Edward Jones or UBS or any of these other brokerage firms. We're not talking about that. That's where you have, the investment rules apply and the investment account rules apply, which differ significantly from the bank and credit union account rules. So we're talking about bank accounts like checking accounts, savings accounts, even certificates of deposit that you have at the bank. Also, what we're not talking about is money market accounts at brokerage firms. So those fall under the securities rules. Many people have brokerage firms and it's like a checking account, but they call it a money market account at a brokerage firm. This doesn't apply to that either. And the rules that I'm going over or the strategies that I go over, they also don't apply to the IRAs that you have at the bank. So many people at the bank, they have a checking account, they have a savings account, they may have a certificate of deposit, and then they may also have IRA accounts, individual retirement accounts, and those IRA rules apply to those individual retirement accounts, not necessarily the bank and credit union account rules that I'm about to go over with you. So just make it clear. But still, even though I said this doesn't apply, this doesn't apply, this doesn't apply, this doesn't apply, everybody has bank accounts. Everybody has a checking account. Many people have savings accounts, and many people have certificates of deposit. So that's what we are talking about. Okay, so I'm going to give you the different rules. And look, I love the live chat. You know it. So all my accounts, including brokerage, are tenants in common with wife. Should my wife be able to use those accounts upon my death? Good question. Happy me. I'm gonna address that. The tenants in common. So you know what? Let me address it just because I so favor the live chat. So all my accounts, including brokerage, which means you have brokerage accounts, are tenants in common with my wife. Should my wife be able to use those accounts upon my death? So I'm gonna give my best shot at answering it, but as a follow-up to my answer, I think you ought to contact the brokerage firm or the financial institution, because as I'm gonna tell you, don't ever rely on the lawyer to answer these questions. Rely on the information that you get from the financial institution where those accounts are held. And I realize brokerage firms are bound by all of the securities rules, but even though they all comply with the securities rules, many brokerage firms will have additional policies that you need to be aware of on these types of things. But I'm going to give you my best answer. Tenants in common, it's not an issue here in Louisiana. We don't have that. We're probably the only state that doesn't have it, but I know enough to be dangerous. So tenants in common, no. Again, check with your brokerage firm, but I feel like if you have a brokerage account with your spouse or with your wife, and it's titled Tenants in Common, and let's say you die and there's $100,000 of investments in that Tenants in Common account, I feel like unless the bank has some other procedure, your half of that account will be frozen, and then your wife's half of that she will have access to, but she'll need a probate court order to access your half of that account. Now, I'll tell you as a side note, I know in many states, married couples title their brokerage accounts joint tenants with rights of survivorship, which is different than tenants in common. Now, I know that when the state permits that and it's titled that way, then joint tenants with rights of survivorship means when one of the joint tenants dies, ownership of the account goes exclusively to the surviving spouse. So then the surviving spouse can access all of it after the death of the first spouse. But tenants in common is different. check with your brokerage firm, but I think that's what we got. What we got going on there. Should my wife be able to use those accounts upon my death? And we're going to get into the bank account stuff here in a minute. So good question. Happy me. I hope it helped. Let's move on. All right. So the 5 options that I'll consider on the bank account. One is to just kind of leave it in your name. And let's say you have a checking account. It's in your name only. Many married people, they'll have an account solely in their name. Maybe they had it when they got married and they just never made it a joint account. Maybe the husband and wife agreed to have separate accounts, and that's how they just like managing their family's assets. Or maybe you're not married and you just have an individual, checking account like so many people do, or savings or CD, and it's in your name only. Well, if you just leave it at that, that's the kind of do nothing strategy. Then when you die, it's going to be frozen. So let's put a name. I'm looking at the television above my camera that talks about Bolton. He's on the headline there. So Bolton has a checking account, and Bolton dies. And Bolton may or may not have a will, regardless. Let's say he did have a will, and let's say he left things to prosecutor. So Bolton dies, he leaves his assets to prosecutor, and he names prosecutor as the executor of his estate. And so when Bolton dies, what's likely going to happen is, as Bolton's funeral gets done and death certificates get prepared, and if Social Security gets notified that Bolton died, and then Social Security stops any kind of bank deposit into Bolton's account, and through that, the bank finds out that Bolton's dead, and they immediately freeze Bolton's account. And so prosecutor can't get to it. Prosecutor has to go see a lawyer, has to get confirmed as the executor, which takes weeks or months. And then prosecutor will open an estate account, estate of Bolton, at the bank, and then prosecutor will have the appropriate court orders to order the bank to release the funds to the estate of Bolton so they can be deposited into the estate of Bolton account with prosecutor as trustee. Sorry I use those names. It's what I saw on the TV screen on the wall. All right, so that's the kind of do nothing, just leave the account in your name strategy. Most people don't like that because it doesn't give access to the survivors for months or weeks or months until after the account owner dies. So what else do people do? The next strategy is to do what it's kind of the, I'm going to jimmy this thing. I'm not going to get any help. I know what I need to do strategy. I'm going to get around. I don't need lawyers to do this. I got this. That's the next strategy, which is take one of your survivors, one of your kids, one of your heirs to the bank, and you add that person as a signer, authorized signer on your bank account. So much confusion about that concept. So first, let me hit the issue on point. If Bolton has a checking account, I'm going to come up with a better name, and he brings Donald to the bank and adds Donald as a signer to the account, does that mean when Bolton dies, Donald can access Bolton's checking account? And as you might imagine, my answer will be, depends on the bank. Most banks, from what I've seen, will permit Donald to access Bolton's bank account if Donald is an authorized signer, but they don't have to. And there are many banks out there that when they find out that Bolton died, even though Donald is an authorized signer on the account, the bank will freeze Bolton's account. And then that executor's got to go through the process of being confirmed and opening an estate account and getting the court orders to the bank to order the bank to release the funds to the executor. So that works sometimes, but not every time. If you've done that, you need to go to your bank and ask the question, I added my son as an authorized signer. If I die, will my son have access to the funds? And they'll give you an answer, and that answer may change because, 10 years from now when you pass away. But don't rely exclusively on the lawyer's advice on what will happen at your particular financial institution. I will also say that, again, here in general, if Bolton adds Donald as a signer and Bolton dies, and let's say Donald can access the funds, being an authorized signer does not mean that when Bolton dies, Donald becomes the owner of that account. That account still is in the estate of Bolton, and Donald, if he has access to the account, and if he withdraws any funds from the account, he's going to be accountable to the other heirs for those funds. Now, maybe Donald will use those funds to pay for funeral services and other expenses, and so all that works out and all of the accounting on the back end, so no big deal there. If wife and I have separate RLT, if I die first, does the survivor have access to my trust? All right, good question. I call you D.N. Preston Sr., who's one of a regular. You and Ron are right there at MVP status as far as, and it looks like you just retracted your message, but I saw it and I'm going to answer it. Husband and wife have, there we go. Okay, got another one here. No, that's okay. I'll come to that one next. Husband and wife have separate revocable living trusts. Husband has his accounts titled in the name of his trust. We'll call him Don because Don's on the screen. And wife has her accounts titled in the name of her trust. And Don dies, can Don's wife access the Don trust accounts? You may have realized the answer, and maybe you retracted your message. I'm getting a message that you retracted your message. But the concept there is when Don dies, you look at Don's trust instrument, and the bank will look at it too, to determine who is the successor trustee when Don dies, or who's the trustee if Don's not able to be the trustee. I'm sure when Don set up his trust, maybe he designated his wife likely to be the successor trustee. Maybe he designated one of his kids. And so whoever that successor trustee of that trust is will have access to that account. So that was, you're kind of, great minds do think alike. That was one of my strategies here in a minute, is make those accounts trust accounts, and then the successor trustee will have access to those accounts when the initial trustee passes away. All right, and then Happy Me, who is another regular, when bank account is frozen upon death, what happens to bill payments paid automatically from that account each month? Will those bills get unpaid? If the account is frozen, the bills will get unpaid. So nothing goes in, nothing comes out. If there are utility bills, mortgage bills, it's oftentimes a good idea for that executor to notify the mortgage lender, the utility company, and say, hey, the account owner died. Their account has been frozen. I'm in the process of getting appointed or confirmed as the executor. I want to keep the lines of communication open. I intend to make sure that you get paid out of the estate assets once I get access to those accounts. And they're usually very willing to work with you as long as you maintain those lines of communication open. So again, we've been talking about a lot about the what if it's frozen, what do you do? And some of the stuff we're about to talk about is the how do you avoid it being frozen? So we've talked about the kind of informal, go add somebody as an authorized signer. That often works, doesn't make that person the owner when you die. They're going to be accountable to the heirs. And even when it's done that way, sometimes there are some banks that will still freeze the account when the account owner dies. Okay, so the next issue, and this is a state-by-state issue, is to set up your bank accounts so they have, if your bank and state permit it, either a POD, payable on death designation, or a TOD, transfer on death designation. I thought there was another question, but I got it. Okay, so I know here in my state we have POD designation, payable on death. Capri, who I see on my TV right now, she goes to the bank and she has 2 children, and she has bank accounts, and she lives in a state, and she banks at a bank that permits her to do some type of POD or TOD designation. So she fills out all of the appropriate paperwork. That's, let's say she did POD, which is what we have in our state, and she signs the paperwork, the affidavits or whatever that she has to do, and signs that when she dies, her bank account is to go 50-50 to her two children, half to child A and half to child B. So a couple of issues there. One is when, oh boy, I can't remember her name, but whenever the account owner dies, the kids aren't going to be able to access it right away. The bank is going to need a death certificate, and that might take 3 or 4 weeks, may take much longer, may take less time. All depends on where you are and what the back order is on death certificates in your particular area or state. So got to be aware that that they're not going to have access to that right away. If you do POD and you expect for them to be able to pay all these expenses that are due within maybe 2 or 3 or 4 days after your death, those funds are just not going to be available for it. Another unique thing, which kind of nobody knows, is, at least in my state, that POD law, it's all in the banking law. And what that law says, the only aspect of the law is that a bank is relieved from liability for paying the account balance to the POD designees. But in our estate law, there's nothing in our law that says those designees are entitled to become the owners of the money. So those designees may be accountable to the estate or the heirs. Got to be careful about that if that's an issue in your state. But that's another issue, POD, TOD. I don't even really know the difference. If somebody knows the difference between payable on death and transfer on death, bring it on, because it seems to be the same thing to me. All right. The other issue is sometimes people mistakenly believe, after they tell me, Paul, at least I know I got that one covered, because I know my daughter can get to my bank account when I die because I've already given her power of attorney. Most people understand that the power of attorney is only effective during your lifetime. So if Mike gives Dana power of attorney and they bring that power of attorney to the bank and the bank's lawyers approve of it, and Dana starts transacting Mike's bank account while Mike is alive, everything's going great. Dana's paying bills. Dana's handling things for Mike. Mike's getting older. Mike wants Dana to do it. Dana can do it. But when Mike dies, that power, the effectiveness of that power of attorney ceases. A power of attorney is only effective during lifetime of the person who gave power of attorney. So they will freeze the account. And now perhaps Dana or whoever the executor is will have to go through the process of getting confirmed as the executor, same process that I talked about earlier, in order to gain access to those funds. So power of attorney doesn't necessarily cut it. And then we've got what has been referred to by the in-person senior, making your bank accounts trust accounts. Also a very popular option that that just often works. So that's where, just like the question says, husband and wife, in your case, sometimes husband and wives have joint trusts, sometimes they have separate trusts. I'm not going to really go into that, but husband has his own trust, his bank accounts. He goes to the bank when he sets up his trust, and he tells the bank, look, I have these 3 accounts here. I have a checking account, a savings account, I have a CD. Here's my trust instrument and the title of my trust, and I'm the trustee of my trust. So I would like to retitle my bank accounts, take them out of my name and put them in my trust's name, because I don't want them to be frozen when I die. I want my successor trustee to be able to have access immediately when I die so they can do what they need to do, distribute the assets to the appropriate beneficiaries of my trust, pay other expenses that are necessary. And I don't want that person that I designated to have any difficulty. So I want to retitle my trust, put them in, retitle my bank accounts, put them in my trust. So that is very common. If that is an option, you may want to chat with your bank beforehand. Some banks will, and some financial institutions will permit you to retitle your bank account without having to get new account numbers. That's really easy because you probably have a lot of bank draft, automatic bank deposit stuff, and it's a hassle to open up new checking accounts with a new account number and redo all that bank draft stuff. So real easy if they permit you to retitle the account without getting a new account number. Little more involved if you have to get new checking accounts. Most people don't want to do that. I don't blame them. So you could look at perhaps one of the other strategies as well about giving your survivors access to the account. All right, so here's often what we see. To give you an example, Fred has a checking account, a savings account, and a couple of CDs. And he has a living trust so that his home and his investments and other things are in his trust because he wants it to make it easy for the survivor or the trustee to be able to take care of things when he dies, sell his house, access the investments, divide them up among the trust beneficiaries. So kind of a no-brainer there to transfer the CDs and the savings account to the trust because those aren't transacted much. It's a retitle and either name someone as a signer. Of course, probably have power of attorney, but that stops at death. Maybe do a POD, TOD, or make it a trust account. So those are the options there. Okay, tomorrow we have 4 more. Tomorrow is a question we get a lot about how to fund a trust, and I just talked a little bit about how to retitle bank accounts into the name of a trust. That's what funding a trust is. People hear the terms fund a trust, they don't know what it means, but it really means taking assets that are in perhaps your name and retitling them into the name of a trust or funding that trust. That's the same thing. So funding is a unique term, but it means retitling. And I think most lay people understand what retitling an asset means. Retitling a home from John Doe to John Doe as trustee of the John Doe Trust, retitling a bank account from John Doe to John Doe as trustee of the John Doe Trust, or an investment account or something like that. So tomorrow's going to be all about the various kinds of assets that you may have, how those get funded. I want everybody to have a phenomenal Father's Day. Really enjoyed all the live chat today. Happy Father's Day to all you fathers out there. Bring on your questions on the comments to my other videos. Like, subscribe, all that stuff. We'll see you tomorrow.